Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. When you are a lawyer and you are arguing a case in front of a court, whether it's a trial court or an appellate court, you have to be careful that you don't create a false impression. Whether intentionally or unintentionally, you should not ever essentially offer case law for things that you know are foreclosed by later case law. And I'm not certain that Jim Griffin was doing that when he talked about the Remmer case. Of course, he called it Reamer, but it's spelled R-E-M-M-E-R, so it's not really Reamer, it's Remmer. But when he talked about Remmer, I don't remember whether it was him or Harpootlian who came up with the idea that it was presumptively prejudicial. Or it may have been Creighton when he was trying to refute that. But basically, one of my loyal subscribers here went and pulled that case online and read it and said, isn't that interesting? The Supreme Court in that case said that any contact with a juror is presumptively prejudicial. If that's the case, how can South Carolina ignore that? And that was a good question. And the answer to it is that they really did not ignore it. But what they did was realize that later cases had perhaps distilled a little bit more clearly what the government's burden and what the defendant's burdens are in those cases. So let's take a look at U.S. versus Remmer. Now here are the facts. The guy was convicted of tax evasion. He appealed. The Ninth Circuit said, sorry, Charlie, not going anywhere. And the reason that they affirmed was because they felt that there was no prejudice to this particular person. But the Supreme Court held the defendant, where he'd learned about this thing after the verdict, that he had a right to a trial or a hearing to determine whether or not it affected the outcome, whether he had been prejudiced thereby. The case is still good for the idea that you're entitled to a hearing. But that's pretty much where U.S. versus Remmer stops. And it is a 1955 case. Let's look at what the U.S. Supreme Court actually said in that case. In a criminal case, any private communication, contact, or tampering, directly or indirectly, with a juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial. If not made in the pursuance of known rules of the court and instructions and directions of the court made during the trial with full knowledge of the parties, the presumption is not conclusive, but the burden rests heavily upon the government to establish after notice to and hearing of the defendant that such contact with the juror was harmless to the defendant. Now, a couple of things here. They're using a term, presumptively prejudicial, that almost sounds like it's an irrebuttable presumption, one that can't be rebutted. But then they go down and say the presumption is not conclusive, which means, okay, the government can rebut it. But then they increase the burden on the government. They say the burden rests heavily upon the government to establish after notice to and hearing of the defendant that such contact was harmless. So essentially, it's really difficult to prove a negative. How do you prove that something was harmless, that something didn't affect something? You basically have to go and ask every juror, did you hear this? What happened? Do you believe? And of course, because it's beyond a reasonable doubt and all of the, like baseball, all ties go to the runner. In this case, all the ties go to the defendant. A heavy burden on the government would be very difficult for the government to meet. But relax, because the government has a little something to say about that later on. Now, this is from a federal case, Kowalak versus Scott, which is a habeas corpus case from the Eastern District of Michigan. Although Remmer spoke of a presumption of prejudice, the court has subsequently indicated that a defendant alleging improper juror contact must demonstrate actual prejudice. In Smith v. Phillips, the court cited Remmer in stating that this court has long held that the remedy for allegations of juror partiality is a hearing in which the defendant has an opportunity to prove bias. Due process does not require a new trial every time a juror has been placed in a potentially compromising situation. Were that the rule, few trials could be constitutionally acceptable, and it's virtually impossible to shield jurors from every contact or influence that might theoretically affect their vote. Due process means a jury capable of and willing to decide the case solely on the basis of the evidence before it, and a trial judge ever watchful to prevent prejudicial occurrences and determine the effect of such occurrences when they happen. Now, that is a case in a district court that recognizes that Remmer was retrenched from in this Smith case, and that Smith is now the law that controls on this issue. And so, in that same case, they went on to say, in light of Smith, the presumed prejudice language of Remmer is no longer good law. All that is required is a hearing at which the defendant is given the opportunity to establish that the improper contact caused actual prejudice. I try very hard not to be like all those other YouTubers who open up every video by asking you to subscribe before you've even seen the content. But now that you've gone a few minutes into the content, if you find this interesting and helpful, please subscribe. I'd consider it a personal favor. Why they didn't take Smith to the judge the other day is really an interesting question. And the reason it's interesting is because if they had taken the Smith case, it has the quotation from Remmer right in it. And they would have had a much better issue where they could have said, yes, and we realize we have the burden now, we have to prove actual prejudice. But for whatever reason, when they made that initial presentation, they didn't do that. And I don't think they were really trying to create a misunderstanding of the law or a misapprehension about their, what they had to prove. What I do think is that if you're going to get caught telling the truth, that's a good way to get caught telling the truth. Judge, Remmer is no longer good law for the presumption of prejudice, but it is good law for having a hearing. We're not offering it for the presumption of prejudice. And that, I think, would have gone a long way to have the judge realize, hey, these guys are shooting straight with me here. And I know a lot of you don't believe that these guys ever shoot straight, but there is a tactical value in shooting straight with a judge. It does pay off later on. By virtue of that, having taken the language from Smith, it would have certainly been a much better and a much smarter way to handle this by going to the judge in that manner. Normally when courts talk about presumptions, they talk about rebuttable presumptions and irrebuttable presumptions. An irrebuttable presumption is one where it just controls. If this happens, then there's an irrebuttable presumption, and such is the way the law works. A rebuttable presumption says, yeah, that happened, but the presumption is that it's prejudicial, but now we get to determine whether or not it actually is. By virtue of switching that so that there's no presumption whatsoever, that the only presumption is that you get a hearing to determine on the basis of the evidence what actually happened in the jury room, I think it's a better and perhaps more fair way to establish that the jury did the right thing, particularly in this case, because I think everybody recognizes that the jury did the right thing in convicting Alec Murdaugh. The only person, I guess, who probably doesn't recognize that is Alec Murdaugh. And I guess maybe the two lawyers. I'm sure they feel that they got the raw end of the deal here in the way that Becky Hill kind of threw a huge monkey wrench in this. But, they ought to include Becky Hill on their Christmas card list, because she just gave them another a gift, a Christmas gift wrapped up. It certainly is one of those things where she gave them something that nobody else could have given them, an opportunity to get a new trial on the basis of new evidence. Now, I also noticed that Creighton Waters brought up the fact that if they'd known about this within the 10 days in which they had to seek a new trial, and they didn't get it in that time, when they had that time to seek a new trial, that they are procedurally barred. And so one of the things that Creighton wants to know is, what did Dick know and when did he know it? Because if he knew it within 10 days that the clerk had made these comments and he didn't raise it in his new trial motion, well, he has a problem. And he doesn't have to have all of the facts and data to raise it in the new trial motion. You could raise it very briefly and very succinctly and say that you're raising this on information and belief, and ask for leave to supplement and amend the motion for new trial after you complete a thorough investigation, which would have been, I think, the better way to do that. It looks like they did not do that, and as a result, they could wind up getting, the judge could actually wind up saying, well, it really looks like the jurors were probably affected by this, but you didn't raise it in time. Sorry about that. You're out of luck. And that would have been an exceptionally bad look for a guy who sits in the Senate and considers himself a really great criminal lawyer. I don't know how they would handle that, but I guess they wouldn't have to worry about Alex suing them because he hadn't been paying him, for one thing. That's what I have for you today. My videos are going to be a little late, and they might not necessarily get out on time because not me, but someone in my family has had a little bit of a medical issue. I've had to spend a lot of time at the hospital this week. And so my apologies for not getting this out earlier. Thanks so much for watching, and come catch me down at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.